Welcome to the Deep Dive. Today, we're going to try to unpack some pretty foundational ideas about owning real property. You know, the land, the rights, how you actually make sure it's yours. We really want to bring some clarity to what can feel, well, pretty complex sometimes. And I think we absolutely have to start right at square one, because this is something that honestly trips a lot of people up. What is the difference between real property and personal property? So real property, sometimes called realty, that's the land itself, and anything, permanently stuck to it, buildings, fences, things like that. If you can't just pick it up and walk away with it, it's generally real property. The big idea is that it's immovable.
Exactly. Immovability. That's the absolute cornerstone. And personal property or personality, well, that's pretty much everything else. Your car, your sofa, even intangible things like stocks. It's movable. And because real property can't be moved, the whole legal system around tracking who owns it, how it gets transferred, it's just fundamentally different. And that's what we're getting into today. We're shifting from, the physical dirt and bricks to the more abstract legal ideas that define who gets what rights. And understanding this is just crucial if you're ever planning to buy or invest. Really essential stuff.
Okay, let's tackle a word then that gets thrown around a lot, but maybe not always correctly in the legal sense. Estate. Most people hear estate and picture like a giant mansion, right?
Right, that's the common image. But legally, it's much brighter. Generally speaking, your estate is just everything you own. Real property, personal property, the whole lot. But when lawyers talk about an estate in real property, they mean something specific. It's not the house itself. It describes the kind of ownership rights you have in that property and how long those rights last. It's your bundle of legal rights, really.
And what's really interesting is how these rights, this bundle, can have real value even if you're not like living there right now. The leased fee estate is a great example, isn't it?
Oh, absolutely perfect example. So imagine you own an office building, right? And you lease it out to a company for, say, 20 years. You don't have possession, the tenant does. But your ownership, that leased fee estate, is still incredibly valuable. Why? Well, first, you get that stream of income, right? The rent payments, predictable cash flow.
Okay, that makes sense. Money coming in.
But there's more. You also keep what's called a reversionary interest.
Reversionary, meaning it comes back.
Exactly. When that 20-year lease is up, the full rights, the possession, everything reverts back to you, the owner. So you've got income now and you get the whole property back later. That combination makes your leased fee estate something you can actually sell today or borrow against. It has present value.
So value based on a future promise, essentially. Which kind of leads us naturally to this idea of a future estate. This isn't about having the property now. It's a right to have it later.
Precisely. A future estate is an ownership interest, but it's not possessory yet. The right to possess kicks in at some point down the road. And the simplest example is that reversion we just talked about. You grant someone temporary rights, maybe for their lifetime or a set number of years, and when that period ends, boom, it automatically comes back to you, the original grantor, like setting a timer on the rights.
Okay, understanding the rights is one thing, but how do you actually prove you have those rights? This is where title and deed come in, and they get mixed up all the time.
Constantly. They sound similar, but they're distinct concepts.
I always think of it like this. Title is the idea of ownership, the abstract legal status. It's the collection of rights and the history that proves you're the owner.
That's a good way to put it. And the deed, that's the physical document. It's the written legal instrument that actually performs the transfer.
The tool.
Exactly. It's the tool used to move the title from the seller, the grantor, to the buyer, the grantee. The deed does the moving. The title is what is being moved.
And this whole system relies on keeping track of everything, right?
Yeah.
Public title records. Why is that public record keeping so vital?
Oh, it's absolutely critical. State laws, these recording acts, mandate that changes in ownership, liens, claims, basically anything affecting the title gets recorded publicly. This creates a history, a chain of title. And if you need a summary of that history for a specific property, that's called an abstract of title.
Okay, so it's a history log.
Yes, but it's more than just history. It's about protection through something called constructive notice.
Constructive notice. Sounds important.
It is. Once a document affecting title is properly recorded in the public records, the law basically says everyone is considered to know about it, whether they've actually seen it or not. You've been constructively notified.
Ah, okay. So if I buy a property and record my deed right away,
Yes.
and then someone pops up saying they bought it from the same seller 2 weeks earlier, but never got around to recording, I'm protected.
You are generally protected, yes, because you're considered a good faith purchaser without notice of that prior unrecorded claim. Your recorded deed takes priority. It establishes who's first in line, legally speaking. Recording promptly is probably the single most important step after closing.
Right, that makes total sense. Okay, so deed recorded, title history understood, constructive notice working for us. But the big practical question, how do I, as a buyer, make sure the title I'm getting is actually good? What if there's some hidden problem lurking in that history?
That's the million-dollar question, isn't it? It's about title assurance. And generally, there are 3 ways people get some level of comfort. First, you can rely on the deed itself, specifically the warranties the seller gives you in the deed.
Warranties, like a guarantee.
Sort of.
Okay.
The strongest type is a general warranty deed. With this, the seller is basically promising the title is clear of any hidden problems, liens, or claims, what we call encumbrances, not just issues that arose while they owned it, but from any time in the past. They're giving you the most comprehensive guarantee they can.
Okay, that sounds pretty good.
What else? Second method. Get an abstract and opinion. You hire an attorney, they review that historical abstract of title we mentioned, trace the records, and give you their professional legal opinion on whether the title looks valid based on those public records.
So a lawyer checks the paperwork.
Essentially, yes.
Yeah.
They check the public trail. And the third way, which has really become the standard in most places, is title insurance. You buy an insurance policy. Simple as that.
A one-time payment.
Usually, yes, a one-time premium paid at closing that protects you, the buyer, or your lender against financial loss if some title defect pops up later on.
Okay, 3 options. But you said title insurance is the standard. Why is it generally considered the best, the most robust protection for, the average person buying a home?
Well, think about the other 2. Relying on the deed's warranty, that's only as good as the seller's ability and willingness to pay up if a problem arises years later. What if they've moved or have no money?
Right, chasing them down could be impossible.
Exactly. And the abstract and attorney's opinion. That lawyer is only certifying based on what's in the public record. They can't protect you against things that aren't recorded.
Like what? What kind of hidden things?
Oh, things like forged documents somewhere in the chain of title, deeds signed by someone who is mentally incompetent, undisclosed heirs who suddenly appear.
Yeah.
Stuff that wouldn't show up in a standard record search.
Yikes.
Title insurance is different. It's a contract with a company that has financial reserves. And critically, it protects against both recorded and unrecorded defects up to the policy limit. It covers those hidden risks the other methods just don't. It's a real safety net.
Gotcha. That makes the case pretty clearly. Okay, let's do a quick, maybe slightly silly example to hammer home what a deed actually does or doesn't do. Let's talk about a quitclaim deed.
Ah, the quitclaim. Always interesting.
So say I want to be funny. I draw up a quitclaim deed, legally correct format and everything, granting my friend ownership of, I don't know, the Statue of Liberty. I sign it, hand it over. Is that legal? Did I just legally transfer the Statue of Liberty?
Well, the act of creating and delivering that deed, yes, that part's legal. You can absolutely do that. And it's a huge, think about what a quitclaim deed does. It only transfers whatever title, rights, or interest the grantor, that's you, actually has in the property.
And since I obviously don't own the Statue of Liberty.
Precisely. You own 0 interest in it. So the quitclaim deed transfers exactly that. 0 interest. Your friend gets nothing of value.
So it makes no promises.
None whatsoever. It makes absolutely no guarantees about the quality or even the existence of the title being transferred. It basically says, whatever I might own, if anything, I'm giving it to you, but don't blame me if it turns out to be nothing.
Perfect illustration. The deed transfers, but the value is all about the underlying title. Which brings us back to why assurance, like title insurance, is so important.
Exactly right. So if we tie this all together, the big takeaways for you listening are, first, always remember the difference between the physical land and the abstract legal title. That title is where the real ownership and value lies. And second, understand that while public records and constructive notice offer baseline protection, title insurance is really the key to safeguarding your investment against those nasty hidden surprises that records alone can't reveal.
Okay, so that leaves us with a final thought, something to chew on. We know the general warranty deed gives the buyer the most protection from the seller, covering almost any title issue from the past, and the quitclaim gives basically none. But there are other types of deeds in between, like a special warranty deed. So the question to consider is, if you accept the deed that offers less than that full general warranty, what specific risks are you taking on yourself? What kinds of problems might pop up later that the seller would have been responsible for under a general warranty, but isn't under the deed you accepted? Where does that risk actually land? Something to think about for your next transaction. Thanks for joining us on The Deep Dive.